Welcome to your studies of public law and statutory interpretation. In this video, I'm going to discuss some concept of public law and public power. Public law may be described as the body of legal principles that apply to public power or to people who hold public office. Public law principles determine the scope of public power, its nature, its limitations, and the procedures by which it can be exercised, as well as who can exercise it. Even though the concept of public power is central to public law, it can be difficult to define it. Public power is typically exercised by people and institutions that make up the government, the parliaments which make the law, the executive which executes or carries out the law, and the courts which interpret the law and apply it in order to resolve disputes that occur in the legal system. At the most basic level, the exercise of public power determines how a legal system and a nation operates. The exercise of public power has the capacity to affect the whole nation. In Australia, the exercise of public power will determine who can and who cannot enter the country, who is entitled to important licences and permissions, such as permissions to mine minerals or develop land or operate businesses. Another example of public power is also how much we are taxed and on what basis we are taxed. For instance, what is the money raised by taxation to be spent on? And how will the various institutions that use that taxation money operate? Institutions such as schools, hospitals, and public transport. These examples show us that the exercise of public power can have enormous impact on almost every aspect of our lives, and they shape the society that we live in. In a very general sense, public power might be described in contrast to private power. Those are the powers that we enjoy privately as ordinary people, or that private corporations or other legal entities recognised by the law have the capacity to enjoy. In a related way, public law typically regulates the relationship between those institutions that exercise public power, or those institutions and ordinary people, whereas private law generally regulates the relationship between private actors. This does not mean there's actually a clear definition between public law and private law. But in this unit, we understand public law to be the body of legal principles that constrain the exercise of public power. And we want you to think about the important reasons why public power ought to be constrained by law. Ordinary people can typically do a lot of things without some law specifically authorising to do those things. So you can enter into a contract to buy a house, or start up a new business, or make any number of other decisions. And when we do those things, we have to comply with the backdrop of law, but we don't necessarily need legal authority to undertake those activities. In general terms, we can do whatever we want unless or until the law prohibits us from doing those things. Now, public power is different from that in an important respect, because at least in our legal system, no one enjoys inherent public power. Rather, public power must be conferred by law, and it has to be exercised in accordance with the law. This reflects an important distinction between those societies that are governed by the rule of law and those societies which are governed by certain individuals or groups who hold power by birthright or because they seized it by force. In our system, the people who wield public power are appointed to do so as representatives of the people, and they're also accountable to the people. We'll explore that concept of the rule of law in more detail later. Another difference between public power and private power is that public power may be much more coercive than private power can be. For example, there are public powers to arrest and detain people, to keep them in prison or in detention against their will. But ordinary people cannot do those things. The law prevents ordinary people from detaining other people. Another good example of the coercive aspect of public power is the power to make laws about taxation and take people's money. An ordinary person cannot take other people's money. That would be unlawful. But state and federal governments are empowered to collect taxation and apply them to public purposes. So we can now see that public power is important, and it's important that it's constrained by law. It's important to understand the legal principles that determine how it can be used and how it should not be used. We should all want to ensure that when governments act, they act within the boundaries of their legal powers and don't overreach them. We should all want to know what the boundaries or scope of government power actually is, so that we have an idea of what governments can do and cannot do. Even if a particular exercise of public power doesn't directly affect you personally, we still might be interested in the scope of what is allowed under public law. It might affect your friends, your neighbours, or society in general. And it's important to know whether the government has acted lawfully or unlawfully, because this is inherent in the type of society that we want to live in. Over time, the concept of the public has become harder to define. As I noted before, public power is generally exercised by people or institutions that make up the three arms of government: the legislature, the executive, and the judiciary. But many powers that seem public in nature are now exercised by private entities or corporations, people who don't actually hold an identifiable position within government. Those people might be understood as private persons, but they are acting with public authority. For example, if you look at your next water or energy bill, you will see that the service is probably provided to you by a private company, not by a government department or agency. Much of our public transport is now provided to us by corporations or companies. Some functions that are associated with state or federal governments are now contracted out or outsourced to private actors. For example, Australian governments pay companies to assist with the detention of people and even to run privately operated prisons. These private legal persons or corporations are not elected by the people, and they're not accountable to the people in the same way that governments are. Their primary motivation may be to increase profits for shareholders, and this is different from essentially public purposes. Although it's important to keep these complexities in mind when we talk about public power and public law, in this unit we will mainly be focusing on the use of public power in those three main branches of government that I've discussed: the Parliament, the Executive, and the Judiciary. Public law is often described as a discipline of legal study in and of itself, but within the broad concept of public law, there are other sub-areas of law that you might be familiar with. These include constitutional law, administrative law, and human rights law, all of which you might be familiar with. In addition, statutory interpretation is treated as part of public law. In this unit, we examine the foundational principles of public law together with the principles of statutory interpretation, as we believe that these topics are closely linked. The power to make statutes is an exercise of public power, and public law principles determine the kind of statutes that Parliament can enact. Many statutes empower or require the government to do certain things. And finally, the principles of public law inform how the courts should interpret statutes. In other words, the process of making, carrying out, and interpreting legislation is one that involves all three branches of government, and the principles of statutory interpretation reflect the relationship between those three branches. This is why we examine the principles of public law and statutory interpretation together. There are now innumerable statutes in the Australian legal system, and they concern an enormous array of different subjects. As the former Chief Justice of the Australian High Court, Robert French, observed, Our legal universe today is dominated by innumerable statutes and varieties of delegated legislation and legislative instruments made under those statutes. The evolution of our legal universe has been dominated by the runaway expansion of statutes, delegated legislation and legislative instruments enacted by the Commonwealth, state and territory governments and their legislative delegates. The common law today is so entangled with statutes that it's difficult to find any legal problem which is able to be defined and resolved solely by resort to the common law. Given the prevalence of statutes within our legal system, it's imperative for every lawyer and every law student to understand how they operate and to be able to interpret them, even if they don't intend to practice in the field of public law. Indeed, it's essential for anyone who wishes to understand the legal system to understand how to interpret statutes. In this video, I've discussed with you the idea of public power and public law, and I've explored the distinction between private law and public law. I've also talked about the relationship between public law and statutory interpretation. We look forward to further discussions with you in class. Thank you.